My name is Mark Thomas, and I'm a member of the local branch committee of the CIArb. Standing to my left in this fantastic tangerine outfit is Sheila Aldred from the local RICS. And the reason why Sheila's here is because, can I just have a show of hands, the people in the room, how many people here are members of the RICS? Could you put your hands up? So it's about half, right. The RICS, without wishing to disparage the RICS, they haven't been exactly active in the branches for a little while. And we constantly get people complaining that there isn't anything going on locally for local people from the RICS. So some of us want to change that. And as a result, there are a few members of the RICS within the regions who are trying to get a database and a following and interest in local events. And Sheila is the nominated person for the Oxford area. I'm just saying everything she probably wants to say. Sorry, Sheila. All right. But so she wanted to come along this evening because a few weeks ago we set this up and we said we'd like to talk to the local RICS, and they said, well, can we come along? We'd like to see if there are local RICS members here, and you've seen the number. And I think Sheila would be pleased to talk to you because we want to try to organise more events. And this is not just Oxford, it's going to be Buckinghamshire, Berkshire and Oxfordshire, BB&O as was back in the day. And then we'd like to get to a situation whereby we have your details. We won't sell them to a third party, we'll just use them for, oh, all right. Well, I won't, Sheila might. And we'll then be organising CPD events locally for people that you might wish to come along to. So that's the aim of the exercise this evening. Sheila, anything you wanted to add to that?
Yeah, just if people want to come and ask, so Mark's helping, I'm trying to get recruits. So I've been asked to be the chairman of the local members group. I've been on the RICS board for 6 years. I'm frustrated that we never really did anything. And I think for the first time ever, the RICS are actually listening, but if they don't move forward, there won't be any RICS. So it's quite nice to actually have good people on board and people that want to listen, people get their members' fees worth. So very happy if people got 5 minutes afterwards to come and talk to me, what kind of events you'd like us to put on. I think I was asked to set up Oxford, but years ago I did Bucks and Oxford. And I think it makes sense to kind of keep those three together and do events across the counties. And talking to the guys here, like to try and get solicitors and surveying firms all together and try and put on some massive events. So when I did it, probably about 8 years ago or so, we were getting 100 people, £10 a head for a glass of wine, nibbles and networking and CPD that people wanted. And I think that's what people really want. And so that's what I want to try and put on. So if anyone's got 5 minutes to come and tell me what it is you want, whereabouts, etc., and we'll all try and work together. And if you're interested in joining me on the group, then please let me know. So,
Sheila, yeah. Thank you very much indeed. Okay, so back to the CIArb element of this. I'm going to start by telling you about our next meeting because, again, hopefully we'll be able to do that in conjunction with the RICS. But we move the meetings around Bucks, Berks and Oxon. Our next meeting is going to be at the end of April, when on the 26th of April in Maidenhead, we'll be having an event on consultants' terms and conditions, getting paid and not being sued. So if you work in the private sector, I would have said it was of general interest to virtually everybody, and that would be also accountants and other professionals. So look on our website, the events are already up there, we're already booking for that, and I'll be sending out a mailing for that. And then finally, back to tonight's main event, as it were, I'm delighted to have Mills and Reeve solicitors who are, well, originally well known for being in Cambridge, but for about the last year, they've now been in Oxford and other area offices. And so I've got Stuart, Thompson and Dominic Jones, both partners of Mills and Reeve. I won't bore you with the details of what it says in the legal terms, but something along the lines of both scarily bright or something along those lines. So you can make your own assessment because they're going to be talking to you about recent developments in construction law. So Dominic, I think you're starting.
I am.
Right. And I'm going to hand that to you.
Mark, thanks very much for the introduction and very good to see you all here. As Mark says, Mills and Reeve now have an office just across the road, so it hasn't been too far for Stuart and I to make the trek over here. And we're also now in Oxford and very keen to be involved in future events. So we'll be coming to speak to Sheila as well. Right, well, without further ado, there's a lot to get through. So put the agenda up on the screen. I'm going to try and rattle through that in under an hour. Ideally, leave a little bit of time for questions, otherwise we will be around afterwards to pick up on anything we haven't touched on. I'm going to deal with the first 3 bullets there, building safety, termination and delay, and then hand on to Stuart, who's going to cover in full detail everything else on the list. So first up, building safety. And I've got 3 cases I'd like to cover under this heading. The other significant development in this area, of course, is the Building Safety Act 2022. I'm not going to talk about that in any detail, partly because there's so much to cover this evening anyway, and because you can find any number of webinars on what we do and don't yet know about the Building Safety Act. And if you do need a summary of the latest position, I can commend to you a panel session being run by Mills and Reeve colleagues you can find on our website on the 26th of April. The first case to talk to you about was Martlett and Mullally. This was the first cladding dispute to be brought to trial in the TCC. The claimant, Martlett Homes, was a housing association, owned 5 1960s tower blocks in Gosport, Hampshire. The defendant, Mullally, was a design and build contractor, engaged in 2005 to refurbish the towers, including by installing external wall insulation to improve resistance to cold and damp. Following investigations carried out after the Grenfell Tower fire, Martlett discovered that Mullally had installed a Stowtherm Classic external wall insulation system that included a highly combustible expanded polystyrene layer with fire breaks and an overcoat of render, and also that the mineral wool fire barriers that were required at each floor had been installed defectively. Martlett responded by organising a Waking Watch fire patrol and investigating a permanent solution. That remedial solution that was adopted was to remove entirely the cladding and replace it with a similar system using non-combustible stone wool insulation instead of the EPS panels. Martlett then sought to recover approximately £8 million in damages from Mullally for costs incurred in remedying the system and providing that Waking Watch. In its claim, Martlett advanced 2 alternative cases. First, it pointed to the workmanship defects that I've mentioned. This is the installation defects case. Second, by way of amended proceedings with the permission of the Court of Appeal, Martlett argued that the cladding system that was specified and installed did not meet the applicable fire safety standards at the date of the contract. This is called the specification breach case. Now, Mullally admitted that there were some defects in the installation of the cladding system, but denied that those defects justified the complete replacement that was in fact carried out. Also denied that justified the Waking Watch costs. Mullally argued that Martlett had in fact replaced the cladding because it realized in the wake of Grenfell that the system did not at that point in time meet the heightened fire safety standards that had come into force after the works had been completed. Mullally, the contractor, said the installation defects only required some limited repair works at a much lower cost than the full installation scheme. They denied responsibility for the full replacement. And in response to that, Martlett pursued this alternative specification breach case. Now, the court found in favour of Martlett, the claimant, on both the installation and the specification breach cases. And the detailed findings, of course, turn on the facts of this case, the specific facts here, but there are a number of principles of more general interest arising from the judgment that I want to touch on now. First, the court found that the contractor was under an absolute contractual obligation to deliver the works in compliance with the building regulations in force at the date of the contract. That's the 2003 iteration. And the wording of requirement B41 from Schedule 1 will be familiar. The external walls of the building shall adequately resist the spread of fire, having regard to the height, use, and position of the building. And in reaching the conclusion that the functional requirements of B41 had not been met, the court carried out a detailed analysis, including findings that the fact that there was an agreement, a BBA certificate covering the Stotherm Classic system did not amount to a guarantee of compliance with the requirements. And although the advice in BRE 135 could have been clearer, a construction professional with fire safety related knowledge working on a high-rise building with sleeping areas should have had regards to the performance standard in Annex A of BRE 135. On the facts of the case, there was no evidence that the system satisfied the relevant performance criteria through a BS 84141 test, which was what the judge considered would have been the only way of clearly demonstrating compliance. In relation to design responsibility, the court rejected what has been described by leading counsel for Martlet, Jonathan Selby KC, as the lemming defense. In the context of an obligation to exercise skill and care in the design of the works, it was not enough to say that everybody else was making the same mistake. The judge concluded that on a proper application of the Bolam principle, a designer could not blindly rely on the BBA certificate or indeed on the practice of others in the profession without, in fact, carrying out a proper inquiry and exercising professional judgment as to the system specified. Finally, the court also rejected Mullally's argument that the costs of the waking watch were too remote to be covered in damages. The need for those temporary safety measures was certainly foreseeable in the view of the court, and to the extent it was not, that merely reflected what the judge referred to as a culture of endemic complacency within the construction sector about the true nature and extent of fire safety risk. And the judge also made clear that he would have accepted Martlet's fallback case, which was that the cost of a waking watch ought to have been recoverable as a reasonable step taken in mitigation of the far greater loss that would have been suffered if it had had to carry out a full-scale evacuation of the towers. The second case, I'm going to not spend long on. This is the second cladding-related claim in the TCC. Judgment was given in December of last year. Many of the court's findings on liability are not surprising in light of the Martlet case. LDC was the freeholder of 3 tower blocks in Manchester, which had operated as halls of residence. The blocks were constructed in 2007 and 2008, and LDC identified defects in the external cladding, which were causing water ingress and deterioration of the structural insulated panels, as well as fire barrier and fire stopping issues. LDC pursued claims under collateral warranties against both the contractor Downing and the specialist subcontractor cladding European sheeting. Before the trial, LDC and Downing reached a settlement in the sum of just over £17.5 million. And at the trial, LDC sought judgment against ESL, European Sheeting, in the sum of just over £20 million. And Downing also sought to recover its losses, its settlement sum paid, along with its reasonable legal costs from ESL, either under an indemnity or by way of contribution under the Civil Liability Contribution Act of 1978. At the time of the hearing, ESL had entered into creditors' voluntary liquidation, so was not represented. But its arguments that were put before the court were that it said its obligations under the subcontract were more limited than Downing's obligations to LDC, and that it was only required to exercise reasonable skill and care in respect of its design role. The court here held that on a proper construction, the subcontract was back to back with the terms of the main contract and imposed on ESL a strict obligation to comply with all statutory requirements, which included the applicable building regulations. So in respect of both the water ingress issues and the fire safety defects, ESL was in breach of that obligation. The court also looked at mitigation, considered whether LDC could have mitigated its losses, for instance, in respect of the deterioration of the SIPs that was caused by the water ingress by remedying the issues sooner. The evidence showed, however, that ESL had been given ample opportunity to carry out remedial works, but had failed to do so. And any delay by LDC was at best limited to the period after May 2017, and in any event was not causative of the scope of the remedial work required. In respect of that remedial work, the judge said the court will not be too critical of choices that are made as a matter of urgency or based on incomplete information. Now, the point around betterment arises from the fact that the remedial work that was carried out by LDC involved substituting the SIPs with a structural framing system and also replacing the glazed panel elevations. The court looked at the case of Sartex Quilts and Textiles, in which the Court of Appeal confirmed the principle that where a party derives a monetary benefit as an incidental consequence of adopting a reasonable reinstatement scheme, a deduction from damages should be made to reflect that benefit. But in the circumstances of this case, the court did not make any deduction for betterment. That was on the basis that LDC here had no reasonable choice but to implement the remedial solution that it selected. And it was important in the court's reasoning that LDC had taken its decisions following expert advice, and the court considered that it was reasonable for LDC to rely on that advice. Now, finally, in respect of Downing's claim for reimbursement of the settlement sum, the court looked at that and said the defects had arisen from ESL's breach of subcontract. That in turn put Downing in breach of its obligations under the main contract, and Downing was acting reasonably in reaching a settlement with LDC. Accordingly, Downing was entitled to a full indemnity from ESL in respect to that settlement sum. The third case on building safety arose in the context of a PFI scheme for an oncology centre in Leeds. So the diagram here on this slide is meant to show a basic structure of the PFI project. And here, the claim related to the contract between the project vehicle and Lend-Lease as design and build contractor. As is often the case, the project agreement here between Leeds Teaching Hospitals NHS Trust and Project Co also contained important obligations relating to the works, and they were passed down into the building contract. So here, the project agreement required compliance with the trust's minimum technical and construction design standards, including Health Technical Memorandum 81 relating to fire precautions in new hospitals. Project Co's claim against Lend-Lease related to fire safety design defects that it said could significantly impact the centre's ability to operate. Lend-Lease sought to deny liability on the basis it said it had complied with the fire safety strategy that had been agreed by all parties, including Project Co and the trust. The court's decision, I'll give you a spoiler, it will be unsurprising once you've seen the provisions that I'm going to show you in the contract, But it decided that the fire safety strategy implemented by Lend-Lease did not comply with the contract, including because it breached the requirements of the project agreement and HTM 81. So the terms of the contract itself included a project agreements clause, which operated to incorporate the obligations of Project Co under the project agreement as obligations assumed by Lend-Lease under the building contract, insofar as those obligations related to the design, construction, testing, and completion of the works. In effect, that incorporated the material terms of the project agreement as separate obligations assumed by Lend-Lease. And that clear intention was reinforced by the fact that those key provisions in the project agreement were replicated in materially identical terms in the building contract. The conflicting provisions clause mentioned on the slide expressly stated that additional obligations in the building contract were to be treated as cumulative where possible, and failing that, the more onerous standard was to apply. So that essentially confirms that the contract was to be read in line with the position the Supreme Court reached in the Hogarth Robin Rigg case in 2017. There was also a non-waiver clause, which made clear that Lend-Lease was at all times responsible for the design of the works and for achieving compliance with all of the requirements in the contract, irrespective of any review, approval, or comments made by Project Co or the trust. And finally, an indemnity clause was there, although that was not decided upon directly. It was in broad terms and described by the judge as a blank check covering breaches of the project documents. So in short, the parties to this building contract had agreed what was described as a very clear and tightly worded set of terms that left very little room for Lend-Lease to escape liability for any non-compliance with those required standards. I now move on to some cases on termination. Look at another 3 cases, 2 of which have a common motif in relation to repudiatory breach. The first, Struthers and Davies, was a claim relating to defective and incomplete work brought by homeowners, the Struthers, against their building contractor, Alistair Davies, and their contract administrator, although the contract administrator claim was settled before trial. The main issue for our purposes related to the manner in which the claimant terminated the building contractor's employment. But a timeline here. So the contract was entered into on the 31st of March 2015. It had a contractual completion date of the 10th of August. The works were in significant delay. By the 10th of December, Davies had ceased carrying out works on site. Now, although the judgment doesn't say it was a JCT contract that was used, the contractual termination mechanisms will look familiar to those of you who know that form of contract. It required 2 notices to be served where the contractor was in material breach of contract or had failed to proceed regularly and diligently with the works. First, a notice of intention to terminate was to be served by the contract administrator. And if the breach specified by that notice was not remedied within 14 days, the employer was entitled to give a second notice to terminate the contractor's employment under the contract. Now, in this case, in fact, the first notice, indeed both notices, were given by the employer. The first ostensibly on the 23rd of December, the second on the 11th of January the following year. Now, the court held that the first notice, that notice of intention to terminate, was not a valid contractual notice. The contract didn't say that only the contract administrator could give this notice, but the court construed the clause strictly and found that to be the effect of the wording. So the fact that the notice had been sent by the employers was fatal to its validity. There were also issues around proper service, so it was not clear from the evidence that the 14 clear day period for notice had been satisfied. Now, the court did find a way to come to the Struthers' rescue. It identified what it called a litany of failures on the part of Davies, including a refusal to purchase materials for the works, taking materials that the employers had paid for and using them on another job, failing to progress the works, and in fact confirming that the works would not be progressed until this other job had been finished. On that basis, the court found that the contractor was in repudiatory breach of contract by the 10th of December, and the employer's notice of the 11th of January took effect as acceptance of the contractor's repudiation, entitling them to terminate the contract and recover consequential damages. I think it's worth pointing out here that the claimants were fortunate that the contractor's breaches were particularly egregious. Had that not been the case, their invalid attempt to terminate in accordance with the contractual machinery could have meant that the employers themselves had repudiated the contract, entitling the contractor to accept that repudiation and claim damages. The next case covered a host of issues, including termination and concurrent delay. Now, this was a contract for the construction of a bus station in Blackburn. And the scheme was nominated, as you can probably tell from the picture there, for a host of design awards. But it encountered significant delays and cost overruns, and that's where things get interesting for us. The council sought to terminate the contract. The contractor, Thomas Barnes, went into insolvency. The administrators, acting on behalf or on the instructions of the Barnes family, brought claims for wrongful termination and for loss and expense. Another timeline here. Now, this is this time just relating to the termination notice itself. So the council issued this termination notice on a Thursday, the 4th of June, by email and by post. The email was delivered the same day. The post notice was deemed received the following Monday, the 8th of June. The council also, on the Thursday, excluded the contractor from the site on the same day that it served those notices. Now, it doesn't require anybody to be particularly eagle-eyed to spot that that exclusion happened before the posted notice was deemed received. I'm going to ask for a quick show of hands. If I tell you that the email notice was not a valid means of service, but the post was, the question for the court was, did the removal of the contractor from the site on the Thursday amount to conduct by the council that was repudiatory in the circumstances? Who thinks that was repudiation? And who thinks it was not? Most certainly thought that was repudiatory conduct. But perhaps slightly unfair to ask you that question without giving you the full circumstances. So the court acknowledged that the starting point was, as most people in this room think, and that if a party terminates wrongfully, that party will normally be in repudiatory breach. In this case, however, the court held that the early removal from the site did not prejudice the contractor and did not amount to repudiation of the contract by the council. So His Honour Judge Stephen Davies reached that conclusion, having decided that the council, on the facts of the case, was entitled to terminate the contract, and the contractor knew that the council was exercising its rights to so terminate. Second, there was no adverse impact on the contractor, as the removal could have been effected 2 days later in any event, and on the fact the contractor had already ceased all activities, all meaningful activities on the site. In the circumstances, the consequences of terminating the contract mirrored contractually those that would flow for common law termination. So in those circumstances, the court was comfortable to say the council had not repudiated the contract. It was relevant also, this is why I say I could have given you fuller information. The slides have disappeared there. Are they coming back? There we go, they are back. This is not working anymore. Sorry, I'll click there. It was also relevant that the termination notice set out 2 alternative bases for termination, stating expressly that if contractual termination was not effective, then the notice should be treated as acceptance of Barnes' repudiation of the contract. So a few quick takeaway points from that case. First, it emphasizes again the importance of serving notices in accordance with contractual requirements. Here, the contractual termination was not valid until the posted notice was deemed to have been delivered. Second, as with the previous case, the judge decided that invalid contractual termination will not always amount to repudiatory breach. And I think it's important to note that in both cases that we've talked about so far, the court was persuaded that the employer was entitled to terminate the contract and the contractor had effectively stopped performing. Where that's not the case and there's no right of termination at common law, there will be a real risk that the terminating party is in repudiatory breach. And third, it's worth recalling that a termination notice can be valid if it presents these 2 alternative bases for termination, one contractual and one at common law. Finally, on termination, this is a case that relates to a series of contracts for the design, manufacture, and supply of business class seats by Optimares for Qatar Airways. Now, in March 2020, having already missed the first set of delivery dates, Optimares served notice of excusable delay in performance, citing COVID-19 and the Italian government's response to the pandemic. Responding to that, Qatar served notices exercising its rights to terminate the contracts for convenience. And the dispute centered on the contractual construction of this clause. The court emphasized that even where contractual arrangements are weighted heavily in one party's favor, the court should look to the natural meaning of the words, especially where the parties are sophisticated commercial entities who negotiated with the assistance of skilled professionals. So it's not the court's role to rewrite a contract to assist an unwise party. And in this matter, it was Optimares who suffered the consequences of being that unwise party. So I'll just quickly pick up on 3 issues of construction the court addressed. First, there was a question as to whether the existence of a separate right to terminate the contract where Optimares was in excusable delay, which is what they'd said they were in, prevented Qatar from terminating for convenience. Now, the court held that the language of the termination for convenience provision was clear and unambiguous in giving Qatar an unfettered right to terminate at will. So these 2 provisions coexisted, and it was for Qatar to choose which one it wished to rely on. Second, the court considered whether the right to terminate was qualified by any other provisions of the contract, notably an express duty of good faith. Now, Stuart's going to touch on good faith in more detail. So for present purposes, I will just say that the court considered this wording here showed the parties did not intend the right of termination to be disapplied or fettered by any other clauses. Third, the court had to look at the financial consequences that flowed from termination for convenience, and it held that where the contractual mechanism had been followed, so giving the relevant notices, then the contract provided the sole remedy and Optimares had no entitlement to reliance damages or any other damages at common law. Specifically, these words, without incurring any liability, meant that Qatar would not be liable for the consequences normally flowing from termination and would only have to pay the purchase price for shipments completed at the date of termination. As there had been no shipments completed at the date of termination, no sums were due for payment, and instead, Optimares had to repay to Qatar all sums that it had previously received. This may seem a particularly harsh outcome for Optimares, and it may well serve as a reminder to contractual parties that the courts will only look to the principle of commercial common sense to aid contractual interpretation, where the natural meaning of the words of the contract are not clear or leave room for interpretation. Where the express words are clear, however, those words will not be rewritten by the courts. I'm conscious of time and I need to let Stuart speak to you as well. So I'm going to quickly go through a couple of cases on delay and liquidated damages. The first is Buckingham and Peel. And here Peel engaged Buckingham to design and build a corrugated cardboard manufacturing plant at Ellesmere Port under a contract based on a JCT design and build. There were significant delays to completion of the project, and Peel sought to deduct just under £2 million by way of liquidated damages for delayed completion. The building works here consisted of 3 blocks. 2 had been completed, but not the third. And the employer Peel was trying to get rid of the LADs clause in favour of unliquidated damages under a general damages claim. There were Part 8 proceedings brought, and the questions before the court were, first, whether the liquidated damages mechanism was void for uncertainty and unenforceable. Second, whether any remedy in general damages for delay was capped at the maximum level of LDs. In relation to the first issue, the contract did not provide for a consistent date for practical completion against which the LDs could be calculated. So there was a contract particulars that set out a date of the 1st of October 2018, and then a schedule dealing with LDs that identified a milestone date for PC of the 30th of November 2018. The contract also didn't deal with the situation we had here of partial completion, 2 blocks completed, the second not. Now, Alexander Nissen Casey, sitting here as a Deputy High Court judge, found a way through those inconsistent provisions. He reconciled them, and as a result, found that liquidated damages could be calculated by reference to the milestone date of the 30th of November. So he found a way of making that clause certain enough to be enforceable. Peel retained its entitlement to liquidated damages for delayed completion. That meant that the court's findings on the second issue around general damages were obiter, but they raised some interesting points, so worth exploring briefly. And this issue arose because if the LD's mechanism had been unenforceable, Peel could have sought general damages for that delayed completion. The court here looked at the recent decision of Mrs. Justice O'Farrell in Eco World, and there it was held that a liquidated damages provision may, on its true construction, be found to operate as a limitation of liability. Now, in Eco World, the relevant wording was liquidated damages will apply at the rate of £25,000 per week, up to an aggregate maximum of 7% of the final trade contract sum. Having regard to the objective understanding of the parties, the judge there decided that this wording operated as a separate limitation on liability for general damages. In Buckingham, the contract included less ornate wording: cap on liability, cap on maximum LADs, 1.9 million. Buckingham said this must act as a cap on general damages, invited the court to follow Eco World. However, in Buckingham, the court decided that on a true construction of the contract, this wording was too narrow to impose a separate limitation on liability in general damages. So we've got here 2 caps on liquidated damages, not in entirely different language, and the courts have reached 2 different conclusions as to whether the wording can be construed as a separate cap on general damages. So I think the takeaway point here is the value of the parties recording their intentions in clear terms, including as to whether a cap on liquidated damages is to apply equally to general damages in the event that the LD's mechanism fails. With that, going to hand on to Stuart. I know there was one further case I was going to go back to, but I'm conscious of time, so I'll pass on to you. I'm afraid I've broken the pointer, so you'll have to
Thank you very much for that.
tap the computer.
Brilliant. Well, good evening. I know why you're all here. You want to hear about Vardy versus Rooney, which I promise, if we have time, I will get onto that case. There is relevance for those of you who work in the world of construction, but only if I have time. Before I get to that wonderful case, there are 5 other themes that I'd like to explore with you. And Dom has already mentioned one of which is good faith. There have been a number of cases over the past year which have dealt with good faith. And the reason for that is that people perceive the phrase good faith, that it has some sort of magicness associated with it. If you have good faith in your contract, it means you can finesse a bad bargain. You may not be able to avoid a bad bargain, but you can make it appear slightly better than the one in which you, in fact, contracted for. And because of the perception of magicness associated with these words, people have tried their damnedest to imply good faith where the words don't even appear within the contract itself. And we've had a couple of cases in the past year which have attempted to imply good faith into a contract. In English law, that's always been a tough sell. The Australians take a more good day approach to that and are quite relaxed about that. But over here, we're a little bit more rigorous in how we deal with good faith. And that idea came up in the wonderful case of Candy and Bose, where in that case, lawyers had agreed a retainer with the defendants and a conditional fee agreement whereby the fee would be uplifted provided that there was a certain outcome of those particular proceedings that the defendants were involved in. Unfortunately, within the retainer itself, the lawyers had also agreed that if there was an out-of-court settlement, they would walk away with £0, shillings, and pence. The upside would have been about 3 million, downside, nothing. And the defendants, without seeking the approval of the firm of lawyers, merrily did a drop hands out-of-court settlement, leaving the lawyers with 0 shillings and pounds. And they raised, hold on, surely you can't do that. That must be in breach of an implied duty of good faith. And that was the argument that they proceeded with before the courts. And that's a little bit of background. Now, the first thing they tried to get over was the Marks and Sparks test, the test that's been there for quite a while, the 5 tests that state you have to satisfy all of them in order to have an implied term within a contract. And in the Court of Appeal, Coulson said, no way. There is no need, it's not necessary or obvious to have a good faith provision within a retainer between a firm of lawyers and its clients. So they thought, no, yeah, I suspect we're going to lose on that point. So they then came in with their postman Pat argument by saying, but surely this is a relational contract between the client and its lawyers. And there is a case, Bates versus the Post Office, in which where you have a relational contract, i.e. a long-term collaborative contract, much like a framework agreement, that it will be a contract where the courts are willing to imply a duty of good faith. And they attempted to rely on that argument to persuade Coulson and others that, come on, 3 million quid at stake here, go with us on this one. Let's see if we can get home on the implied duty. Coulson was a bit grumpy about implied duties, and he said, no way, that there have been, in his terms, an avalanche of pleadings attempting to increase the implication of good faith within contracts. And he used this particular case to say, I'm putting an end to it. So if you fall within the Bates and Post Office type of contract, you may well get home. but certainly the courts are seeking to narrow that particular scope itself. So unfortunately, in that case, the solicitors were unable to recover any money from their clients. I can sense your tears around the room at that. I was hoping for a bit of a sympathetic, oh no, but no, thank you very much for that. But in any event, if there had been either an implied duty or an express reference to good faith, would that have helped? And I go back to the magicness of what does that term mean? And the magicness was discussed in a case which I'll come on to. But before looking at that particular case, let's go back to 2021. Most of you in the room, no doubt, are familiar with the NEC form of contract. And the Van Ord and Dragados case looked at that form of contract, and it decided that the spirit of mutual trust and cooperation is in essence akin to a good faith obligation. Now, JCT in part 2 of one of the schedules expressly refers to good faith. NEC doesn't, but the courts have decided that the phrase a spirit of mutual trust and cooperation is not merely, as I've said there, an avowal of aspiration, but is in essence a good faith principle. And there was a little bit of guidance from the inner house in this case in Scotland, where they said that what that really means is that a contracting party will not be entitled to take advantage of its own breach. And in this case, Van Ord had structured its pricing based upon a blended rate for certain types of work that it was carrying out on behalf of Dragados. Dragados omitted the easy bits of work, left in the tricky bits of work, and gave the easy bits of work to another contractor. And it wasn't just a small amount of work, it was just under 50% of the contract was given to another contractor. They then priced the emission using the NEC rules based upon that blended rate, and they were quids in. And in that case, the judge said, no, you can't do that. You're in breach of clause 10.1. Therefore, you cannot have the benefit of the assessment of compensation events that arise under clause 60 or 63 in this case. Of more import is the compound photonics case. And in this case, we had a series of wily investors who were able to elbow out of the way the brains of the operation, who were the inventors. And the inventors were a bit grumpy about this. They thought Hawaii, all of those things that they were going to retire to, but unfortunately they were ousted from the company, which was reliant upon their own inventions. And in this case, it went to the Court of Appeal. Snowden, Lord Justice Snowden, looked at some of the cases where there is a badge of good faith and a line of authority that is developed alongside that badge. And some judges, and I've just written down a few, have decided that if you have a good faith badge, it automatically means that certain things apply to your contract. So for example, you are not able to manipulate for an ulterior motive your position under a contract. If you have good faith, it automatically means you must act transparency, full and frank disclosure, no deception, and you can't start a groundless dispute. And there are others as well. So you've got this line of authority saying good faith as a badge opens up this minimum standard, this formula that applies. And Snowden was quite clear to narrow that down. He said that is not allowed. If you have an express provision of good faith in your contract, it doesn't mean there is automatically a set of minimum standards. Instead, he preferred the line of authority that followed a Compass decision, which was a few years old, that said that where good faith occurs within a contract, you must look at the context in which it is used. So what do the words say? No more than that. So he preferred a much narrower view of good faith. And in essence, he said that good faith, there is no formula. It means you must act honestly. You shan't act in bad faith. What does bad faith mean? It means that you cannot act in a way which is commercially unacceptable to honest and reasonable people. And I can see a whole host of disputes around how far can you stretch that, that particular test. So picking up on Dom's case that he looked at earlier on Optimares, here we had, as Dom has already taken you through, a pretty robust termination for convenience clause. Good faith was absent from how that clause was to be operated. And therefore, as Dom has explained, the beneficiary of that particular clause was able to operate it without going back to the good faith provision, which sat elsewhere in the contract and was limited to certain clauses within the contract, but certainly not the termination provisions. So from this, we see that good faith is being narrowed down to a much more sensible test, a test that we probably had 10 or so years ago. So moving on to exclusion clauses, and here there's a wonderful case relating to an energy for waste processing plant up in Hull. Loads of stuff in here. If you're interested about suspension, causation, termination, this is a case that no doubt you'll get stuck into. I'm interested in it because it deals with exclusion clauses, and particularly how willful default sits with an exclusion clause. And in this case, the employer, Energy Works, ended up terminating the contract because High-Tech was so late. And High-Tech had terrible problems with its subcontractor. It couldn't sort out the technology relating to the feeder system. And it was so late that in the end, the employer got fed up with life and just got rid of them. However, as you can see on the screen, their costs were phenomenal in getting rid of the contractor, replacing the contractor, and the lost revenue and so on that resulted from the delays. They were keen to avoid the exclusion clause within the contract. And the way they did that, they looked at this particular provision within the contract where good faith is referred to, but importantly, it says that the parties shall promptly disclose full information to one another. And this was the downfall for High-Tech, because for a number of months, probably a year or so, they knew they were never going to be on time. They hadn't sorted out the technology and they were always going to be late. However, at monthly progress minutes, how's it all going? Tickety-boo. We are loving life. We'll be ready. Don't worry about us. But your kit is in pieces on the floor. We're not convinced by this argument. Don't worry, we'll make up time. How many times have we heard that from contractors, a monthly progress minutes? Yes, it may look as if we're behind schedule, but we're definitely on schedule. Well, that sort of argument, unfortunately, was the main reason why, in this case, the claimant was able to prove willful default. So it pointed out to a whole host of correspondence between High-Tech and its subcontractor. And in that case, the judge decided that willful default, as it says on the screen, is an intention to do something which he knows is wrong or is reckless regarding that particular action. So if you have a contractor who's a little bit fast and loose with the program and is telling one or two things, then it ought to be slightly more concerned than maybe last year with whether willful default will enable a client to walk around a cap on liability. And we are seeing more caps on liabilities where willful default is excluded along with death, fraud, PI, all of those other good things that you often see in there. The other exclusion clause, which I'm afraid a bit more good faith in here and a bit more Coulson, relates to an IT system that IBM were required to provide for CIArb. And that was late, never delivered. And in essence, IBM tried to walk around its own breach by arguing that when it submitted an application for payment for just under £3 million, and CIArb disputed that application, the dispute was not made in good faith. And in their the judge looked at good faith and all of those things that I've already touched upon. She considered those at first instance and decided that provided you are genuinely pushing back on an invoice, that is fine. You're not acting in bad faith. You're entitled to do that. So that meant that IBM were in repudiatory breach and CIArb accepted that breach and terminated the contract. Again, a huge amount of money arising out of the termination. And in this particular case, CIArb had already paid IBM a massive amount of money. I think it was 34 million or so. Just double check that figure. Yeah, 34 million. They'd incurred 42 million pounds in financing costs and paid other costs to third parties to try and get this kit up and running, all of which they badged as wasted expenditure. And they badged that for a reason, because wasted expenditure wasn't referred to within the exclusion clause. Notwithstanding that, at first instance, the judge, she disagreed with that particular argument and stated that wasted expenditure was captured by the exclusion clause. So it went to the Court of Appeal. So this is the exclusion clause. It's fairly vanilla, and we often see many exclusion clauses in that sort of fashion. But the main area was the final few words, the loss of profit, revenue, savings. That was the part of the clause that the judge at first instance relied upon. And in the Court of Appeal, Coulson reminded everyone that there are 3 or 4 important points that we ought to remember when looking at exclusion clauses. The first is a Gilbert Ash, a very well-known case from the 70s, that says that neither party intends to abandon any remedies and clear words are required to rebut this presumption. Then there's an interesting case, the Kudos case, which I'll come back to. And finally, the Amseng case that says that where costs are incurred in reliance on another's performance, i.e. I've paid IBM 34 million, we ought to assume that had we performed the contract, I would have recouped enough money to cover those costs. And Coulson said that in his view, that wasted expenditure was recoverable, disagreeing with the first instance judge for a number of reasons. The first is when you look at the exclusion clause itself, there is no reference to wasted expenditure. And if that had been the intention of the parties, he is saying, based upon Gilbert Ash and other authorities such as that, you should have referred to it, and you chose not to do so. He also said that wasted expenditure can be ascertained at the outset. You sort of know what your break-even costs are when you sign the contract, question mark, but you don't really know what the loss of profits will be. They are far more difficult to ascertain. Therefore, wasted expenditure and loss of profits are 2 different things. And you can exclude loss of profits, but it's harder to exclude wasted expenditure. And the final point that he mentioned in his judgment was the loss of bargain in this case wasn't the loss of making a profit per se, it was the loss of the IT kit itself. And that's a different type of bargain. And because it's a different type of bargain, in that case, you should be entitled to recover what's called negative interests, i.e. wasted expenditure, but you may not be able to recover your positive interests, such as loss of profit. I'll come back to the Kudos case because no doubt those of you in the room are thinking, well, why not just include wasted expenditure in the exclusion clause? And that's exactly what happened in the Kudos case. And in that case, the court said, hold on, you've gone too far. And I'll just get the phrase that the court used there. It said, you have, in essence, excluded every single type of claim that could be brought by a person who is the innocent party to the breach. Therefore, the entire exclusion clause is devoid of intent and therefore does not apply. So don't go too far in thinking, I'll just add everything in to an exclusion clause, because there comes a point when the elastic band will break and the courts will try and maneuver around your good drafting. So we've rattled through two things, good faith and exclusion clauses. And before we look at Wagatha, I'm going to do with a couple of things that construction lawyers love: collateral warranties and novations. And I'll be very quick on collateral warranties, because no doubt you looked at this last year. So this case has been rattling around for a while, and in essence, it reconfirms the decision of Aikenhead and Parkwood that a collateral warranty can, in certain circumstances, amount to a construction contract for the purpose of the Act. Therefore, adjudication is open to the parties under that particular instrument. It went to the Court of Appeal because at first instance, Bowdry decided it was not a construction contract, and eyebrows were raised, and there was a perception that that is a different decision from Aikenhead in Parkwood. And I've summarized on the two green boxes why, or the sorts of discussion that took place at the TCC Love-In in the Court of Appeal between Coulson, Stuart Smith and Jackson. And in essence, on the left-hand side, you can see the Simply warranty, which is in the case that we're looking at. It only has the contractor warrants that, and then the rest of the bump that follows. Whereas in the Laing-O'Rourke warranty, it was Laing-O'Rourke warrants, acknowledges and undertakes that. So the addition in the Laing-O'Rourke warranty was of the verb to undertake. Everyone agreed, acknowledges, waste of time, doesn't add anything, therefore move on. And the other discussion between Coulson and Stuart Smith was the interplay between sections 104.1 and 104.5. 104.1 is pretty clear. A construction contract means an agreement which a person for carrying out of a construction operation, whereas 104.5 is slightly looser. It includes the verb to relate to a construction operation. And Coulson said that you need to look at 104.1 and 104.5 together. And because 104.5 is broader in its context, the relation to, relates to, it felt, or he felt, that the intention of the Act was to capture instruments such as collateral warranties. And Stuart Smith disagreed with that quite vehemently. He said that section 104.5 adds nothing to that debate. The important section is 104.1, and because that says for the carrying out of construction operations, he felt that that was limited to construction contracts, primarily between an employer and a contractor, or a contractor and a subcontractor, not collateral warranties. And he also relied upon the fact that the Parkwood warranty included the verb to undertake, i.e. to do something, whereas the Simply warranty just had to warrant, i.e. something less than to undertake. And Coulson felt that that was too in the weeds. There wasn't a real distinction between those two. Let's not worry about that. They both sort of mean the same thing. And that's why he felt it was a construction contract rather than something else. So Jackson had the deciding decision, and he said that the warrant in this case can either be a promise to perform, or it can be a promise to compensate. So which one was it in the Abbey Healthcare decision? And he said it was pretty clear that what follows is true and makes itself answerable to Abbey if it is not performed. So he decided that the promise in the Abbey warranty was a promise to perform diligently its obligations under the contract. Therefore, the decision was that it was a construction contract for the purposes of adjudication. I would like to say that's the end of the story. However, it goes before the Supreme Court later this year. So whoever is standing up here next year will be wittering on about Abbey and Simply. Which takes us on to novation. And as someone commented on last year, the most bizarre name of a defendant company you'll ever see. But we have no idea why, other than he's a very wealthy individual and may not want to draw attention to himself. And in this case, Gamma Aviation undertook aircraft servicing for, I'm not even going to bother to go through the MWW defendant's name. But Gamma wasn't initially the provider of those services. Gamma had bought the initial provider of those services and then stepped into its shoes via purchasing its shares and so on, but still provided the aircraft support services to the owner of the aircraft, who accepted them, enjoyed them, but didn't decide to pay when asked to pay for them. It said at that point, well, hold on, my contract was with Jet Inc., not with Gamma Aviation. We have not formally entered into a novation of that agreement. Therefore, I do not have to pay you. And the disagreement proceeded to the High Court. And in that case, the judge said, it has been known for some time, following decisions such as CIArb, that you can have an implied novation of a contract. It doesn't have to be in writing. And MWW were expecting that sort of resistance from the court, which is why they referred to this clause in the contract that said that termination can only occur to the extent that one party provides notice in writing to the other. So the judge sidestepped that with remarkable ease, as the Irish sidestepped the English over the weekend in the same fashion. And he said that the words set out within clause 9 only apply to a unilateral termination. Dom wants to terminate my contract, not as an exclusive code if we both mutually agree to novate the contract to a third party. So he dealt with that very neatly. There was also some good stuff about estoppel, which we'll go on to maybe another time. But I'm conscious you've got another lecture in Maidenhead, was it? Coming up on professional appointments. There's also an interesting point in the case around assignment. So for a long time, lawyers have always said you should not assign this contract without the consent of the third party, not to be unreasonably withheld or delayed. So there's some good judgment in there around what does that mean. And in essence, you have to act rationally when deciding whether or not to give your consent. You can't just be a little bit difficult about it, because if you are difficult and irrational about whether or not to provide consent, then the contract will be interpreted as if consent has been not required, as if consent is no longer required. So watch out for that. So I promised I would get to our dear friends, Colleen and Rebecca. And it comes up because over the course of the past year, there have been loads of decisions about evidence, whether memory is better than documents, shock horror, the proverb, as I put there, the palest ink is better than the strongest or finest memory. That still holds true, that if you have a document, that will always trump a witness's memory. And it no longer has to be a document. The interesting case of AM Construction, where a process server said, in the envelope was the notice of intention to adjudicate, and the recipient said it was never in there. That turned on the fact that in the process server's evidence, he said, I rang the bell, I met with no response, and then I left. But one of those little ring modern doorbell things had recorded him putting it through the post and then walking away. And I think that then scuppered the credibility of his evidence, as it did our dear friend Rebecca Vardy with her quite bizarre WhatsApp messages. Not only is the finest document, palest ink, whatever I've said, dodgiest WhatsApp message is better than the quote finest memory. And for those of you who are in the room and act as experts, there've been a whole host of cases where experts have strayed beyond independence and into an advocate for the party who is providing the instructions. And this can happen quite easily if instructing solicitors comment on the expert's report. If you go beyond picking up typos, then the courts are saying you as an expert are moving outside of independence and straying into the world of being an advocate for a particular party. And also be careful about the language you use in front of any tribunal, whether it's adjudication, arbitration, or judges. If you start to say our case is that, then that's a cell that that you're probably not quite as independent as you should be. And there was an interesting case about procurement and experts, which I can discuss after over wine if needed. Mark, I think that's probably it.
Sure, thank you very much indeed. Yeah, you've got the radio mic.
Oh,
And no, just keep it on. So, ladies and gentlemen, we've got time for a few questions. I want to wrap up. So, have we got any questions online, James?
I had a question for Dom. I was interested on the betterment point that's coming up, where it seems to be that the courts are keen to ensure that that betterment argument falls away. Are you seeing betterment being referred to within exclusion clauses to try and hedge against that type of loss, that the courts are more receptive to pay out? Or is it not yet worked its way through the system?
I haven't yet seen it in exclusion clauses. I think I think one of the messages that comes through from the cases that we look at is that express wording in contracts, if you can spend time at the outset thinking about what the consequences of a particular circumstance should be and provide for those consequences clearly in your contractual drafting, that's going to do away with any potential uncertainty and dispute around what was intended by the parties when they entered into their contract. But I will take a note and make sure that I do exclude.
If you can, the government is keen not to exclude anything around Building Safety Act, from what I can see. But yeah.
Of course, the strongest line comes between what happened in Kiddo, where the decision said that the institution was overly onerous, and in comparison to Qatar, that's an example where said, well, business consent, so you signed up to this. So how does it?
Was a tough old termination convenience clause.
I mean, I had, listening to Stuart talk, the same point occurred to me, and I mean, I guess the point with kudos is that if you exclude everything, then it drives the coach and horses through the purpose of the contract altogether. What's the point in having a contract if you're saying essentially, if I'm in breach of this contract, there is no consequence to that? It's where the court sees that trend going. I don't know whether there was anything about the level of sophistication of the parties and how well they were advised, but that was certainly an important issue in the Optimiers and Qatar case.
Yeah. And in Optimiers, it was only around termination of convenience. So if
Yeah.
there had been breach, then there would have been other provisions within the contract that would have helped the innocent party in that regard.
David.
Well, when you get to the point of termination, start falling outside by the contractor. Because then one party can unilaterally terminate and pay no compensation. Then it starts to feel as if there isn't actually a contract.
Yeah, it's a fair challenge. Most termination for convenience clauses that we see, there is fairly hefty direct cost that flows as a consequence of that termination, which the party seeking to rely upon its right to terminate understands it will have to pay out. But I agree that Optimiers looks slightly tough on one party, but yeah, it's yeah, I would agree with
Yeah.
you.
Kevin, right here.
So would the courts then take a view of relative sophistication?
Repeat the question, Steve.
Yeah, so that there is that, do the courts take into account the sophistication of the parties when interpreting contracts generally?
So in certain circumstances, yes. For instance, consumer contracts, there are regulations around making sure that consumers who are in a relative position of inferior bargaining power are not disadvantaged. Unfair Contract Terms Act can come to the aid of a party who's had an unfair set of terms imposed on them. I don't think it's getting at the point in Optimiers is getting at a very detailed assessment of who was more sophisticated than the other. And indeed, it was recognised that although both parties there were sophisticated commercial entities, well advised, the terms of the contract were very heavily weighted in favour of one over the other. So I think the key point was that they were both well advised, both sophisticated commercial entities, and therefore had to live with the bargain that they had reached. But it is a punchy outcome.
It's punchy, and it probably just is a reflection of where the courts are reinterpretation generally at the moment. It's literal. We will look at the words, and even if the words may end up in a result that seems slightly eyebrow raising, well, as long as you revise properly, that's what the words say. Almost moving back from where Hoffman was about, well, let's give it some common sense behind the scenes. The courts are still, in my view, still firmly of the, will give credence to the words, even if it leads to a slightly eyebrow raising conclusion or interpretation.
James?
Over the last 12 or so, 24 years, sort of as you alluded to, there's been an attempt to sort of review good faith with certain characteristics that people suggest should apply to all contracts that have good faith. Do you think that's past its high watermark and perhaps going away now?
I think it is coming down. If you look at the Photonics case, the Court of Appeal is trying to narrow down the perception that good faith equals minimum standards, and that equals 1, 2, 3, 4, 5, 6. Snowden's trying to limit the breadth of that, but commercially unacceptable to reasonable and honest people. That, to me, is right for a scrap about how far you can extend that.
Paul, that was your last question.
Yeah. I struggle with it. I think it should be not used for in a contract when you've got 2 or more parties who hopefully are going to be handing down about what they're doing. I know it's not perfect world. I can see in court it might be used, and then I'm thinking of the one case or 2. ginger beer and not a snail at the bottom of the thing. So, but there wasn't a contract. That was supposed to be drunk in. But in contract, yeah, I mean, I think word faith should be confined more to religious, maybe to try and avoid that, because as you say, judges have to define what it is. Is there any way we could sort of, I mean, I actually believe, I think, to quote a very famous line from Jesus, let me, no. But, you know, let your yea be yea and your nay be nay. You know, let's define it as best we can. Is it not a cop-out? I'm sure there'll be some sort of.
Oh, can I put on a question? Yeah.
Struggling to see the word faith in a contract.
Indeed, and what you mean by reasonable, and what
Yeah.
you mean by all the other weaselly words that we drop into contracts, hoping that people behave sensibly.
Functionality.
We'll leave that hanging.